Okay, the subject I'm going to teach you today is employment law, or it is also known as the labor law. So if you can see from the slide, so there are 7 statutes which I've chosen here. So why I've chosen these 7 statutes? Because this is actually the main statute. When we are going to do employment law, these are the statutes which we need to refer to. However, for this subject, I'm not going to discuss this statute in detail. What I'm going to do is that I'm only going to introduce to you what is this statute all about. Okay, the first statute is the Employment Act 1955. So this Employment Act talks about the rights of the employees, what the employees can gain from this act, whether the employee is entitled to annual leave, maternity leave, whether they are entitled to overtime pay. So all this is actually provided inside this statute. So however, this Employment Act is only for private sector and not for government sector. And if any of this right is not given to the employee by the employer, then what the employee can do? The employee can lodge a report at the labor office, and then the labor office will conduct an inquiry with regards to the infringement of those provisions. And then the second statute is the Employees Provident Fund Act. So this is the EPF or KWSP in the Bahasa Malaysia. So this statute actually provides for saving during retirement age. And this EPF is not only applicable to the private sector, it is also applicable to the government sector. It's just that for government sector, the employees of the government sector is given an option as to whether they wanted to contribute to this scheme or whether they wanted to contribute to the pension scheme. So this EPF, the contributions will be deducted from the salary of the employees. A certain portion of the salary of the employees will be deducted, okay, and will be put inside this saving account, and a certain portion will be contributed by the employers. So after the employees have reached the age of 55, then they can withdraw the whole amount from this saving account. Then the third one, this is the Workmen Compensation Act, and the fourth one is Employee Social Security Act, and actually both statutes is actually a form of an insurance scheme whereby if an employee suffer injury while they are working, then they are going to be protected under this statute. So Employee Social Security Act is also known as SOCSO or PKSO in Bahasa Malaysia. So these look as if quite similar with the EPF fund. However, whereas the EPF fund is actually a saving, this is in the form of insurance scheme. So the fund is also from the contribution from the salary of the employees, meaning certain portion will be contributed to this fund and a certain portion will be contributed by the employers. So however, if the employees did not suffer any injuries while they are working, then they cannot actually claim the benefit under this statute. So meaning if only the employee suffer injuries or maybe in the course of death while the employee is working, or when they wanted to go to work or coming back from work and then suffer injuries, they are involved in accidents, then it did not only protect the employees, meaning the employees is entitled to the benefit. However, the dependents of the employee, the wife, the children also, if in the case of death, they are entitled to this benefit. So what about Workmen Compensation Act? This is actually for those employees who is not covered under SOCSO, then they can actually claim under the Workmen Compensation Act. So number 5, this is the Industrial Relations Act, the IRA. This is an act which actually caters trade disputes. When there is a trade dispute between the employers and employees, a trade union of employers, trade union of employees, then this is the act which caters that problem. So when the case is being taken up to the industrial court, this is the act, this is the statute which we will be referring to. So number 6, the Factories Machinery Act and the Occupational Safety and Health Act, both statutes actually, the objective is the same. The provision of both statutes talks about the safety, welfare and health at workplace. The difference is that the Factories and Machinery Act only covers those premises whereby there is a machinery on that premises. So meaning, if there is no machinery on that premises, it will not be covered by the Factories and Machinery Act. Whereas Occupational Safety and Health Act, OSHA, the coverage is much more wider, and in fact, it also covers government sector and private sector, and also outsiders who is being affected by the act of the said industry. Okay, so that is all the 7 statutes which we need to know when we are doing employment law. So now let us go on with what is meant by an employer and who is actually an employer and who is actually an employee under the Employment Act. Employer, according to the definition of Employment Act, is any person who enters a contract of service to employ any other person as an employee. Whereas employee is a person who enters a contract of service with employer and the wages of that employee does not exceed 2,000 ringgit a month. So if we refer to these 2 definitions, it emphasizes on the words of contract of service. So meaning, if the contract is a contract for service, then this is not an employee. So meaning that person is an independent contractor. So if that person is independent contractor, meaning the contract is not a contract of service and the contract is a contract for service, the employee cannot claim for all those rights under the Employment Act against the employer. Okay, so we are going to discuss how to determine this contract of service and contract for service later on. So now let us have a look at the definition of employee under the Employment Act when it says here the salary or the wages cannot exceed 2,000 ringgit. So meaning for a workman whereby the salary is more than 2,000 ringgit, that workman will not be covered by the Employment Act. So meaning they cannot claim those rights which is being given by the Employment Act. So however, the Employment Act, under the schedule inside the Employment Act, it has listed down 5 types of employment, whereby though their salary is more than 2,000 ringgit, they are still considered as an employee and they are still entitled to claim for these rights under the Employment Act. So meaning they are being protected by the Employment Act. They are still entitled to claim this protection. Who are these workers actually? So the first one is the manual labor. So a manual labor is a laborers who work with their own strength. Okay, example like the worker who work at the construction or worker who work at the plantations. So all these are considered as manual labor. Okay, and secondly, a workman who engage in operation or maintenance of any mechanically propelled vehicle operated to transport either passenger or goods. So an example to this are driver or lorry driver, bus driver, then who else? Mechanics working at the workshop. So all these people is covered under number 2 because they involved in operating and maintenance of this kind of vehicle. So they are still protected under this exception. So meaning if they earn more than 2,000 ringgit, they can still claim their rights under the Employment Act. And number 3, this is the supervisor of manual labor. So supervisor of manual labor, if they earn more than 2,000 ringgit, they can still be considered as an employee. So number 4, if a person engaged in vessel, what is a vessel? A vessel, a ship, a ferry is considered as vessel. These are transportations on water. Okay, so these are considered as vessel. So if a person engaged in a vessel, okay, and they earned the seller, okay, they earn more than 2,000 ringgit. So they are being considered as an employee. However, if they have a certificate from the United Kingdom or certificate from other local authorities like the Alam, Academy Law Malaysia, they have certificate from Alam. So this worker cannot be considered as employee. Okay, only if there is no such certificate. And finally, a domestic servant. A domestic servant is actually a worker who works at home. Example, the butler. So they work cleaning. A butler actually is the head of servants, right? So these servants, they are considered as domestic servant, and they are actually covered by this Employment Act. So now, let us differentiate between a contract of service and contract for service. Why? Because this now, I have highlighted to you, I said, to be covered under the Employment Act, the contract must be contract of service. Why? Because if the contract is contract for service, then you will not be considered as an employee. And if you are not an employee, you will not be protected under the Employment Act. So how are we going to determine whether the contract is a contract of service or whether the contract is a contract for service? So if a contract of service is more than 1 month, of course it needs to be in writing. And according to the Employment Act, there is a definition of contract of service. So let us have a look at this definition which is being given by the Employment Act. It says that any agreement, oral, writing, express or implied, whereby one person agrees to employ another as an employee and that other agrees to serve his employer as an employee, and this include an apprenticeship, include a training. So this definition given by the Employment Act is not conclusive. Why is it not inclusive? Because it says once there is an agreement by one person to employ another and that person also agrees to serve this fellow, then this is already, and this is actually a contract of service. So if I engage a lawyer to conduct my case, okay, so meaning that lawyer agrees to serve me and I also agrees actually, okay, to employ that lawyer to work for me. However, only for that particular case. Then will this be considered as a contract or service? No, actually, because the lawyer actually, this contract is a contract for service. However, by looking at the definition, how are we going to differentiate that? And because of that, because this definition is not conclusive, okay, tidak begitu sahih, we are then going to look at the test which is being laid down by the common law. So the first test is the control test. Kita tengoklah ujian ini ya, control test. So under the control test, we are going to rely on the ability of the employer to control over the employee with regard to work done by the employee. Okay? So how far actually the employer can control what is being done by the employee. If the employer can control this employee with regards to the work done by the employee, we said that this is his employee. However, this test is also not conclusive. Why is it so? Because we cannot control professional. How are we going to control a lawyer? How are we going to control a doctor as to how they need to perform their job? And because of that, we have the second test, which is the organizational or the integration test. So this test actually, we are going to look at the work done by this employee and whether this work is integral of the business. Meaning, is it necessary to complete this task? Is it necessary to have this employee? So we are going to determine whether the work done by the employee is part and parcel of the organization. So whereas if the contract is contract for service, the work done by the employee is actually only accessory to the said business. Then the contract, you said, is the contract for service. Then under this situation, of course, we are going to look at the degree of integration of that work into the organization. And actually, this test would only work if the extent of integration is not ambiguous. So meaning, if it's uncertain, then we cannot use this test. So the work done must be something which is certain. If the employees is actually the clerk in the organization, and that at the same time the employee also is actually the cleaner, at the same time the employee is also the one who make decision, then though we said that his job is very important to this organization. However, if this employee do almost all the tasks, and maybe actually this employee is an independent contractor, that is actually his own business, right? So that's why we have the third test. This is mixed or multiple test. And the indicator as to whether an employee or not under this test, we have these four indicators. The first one, the power of selection. Who has this power of selection? If the employer is the one who can select as what type of work need to be done, which type of worker is suitable for that job, which type of worker need to be hired for this task, then we said that this is an employer and the other parties is an employee. And second one, the payment of wages or remuneration. Who pays the wages? If the wages being paid by the employer, then this must be his employee. And third one, who have the right of suspension and dismissal. If the employer is the right to suspend this fellow, then under the situations, then this fellow is said to be an employee of that person. And number four, the right of control. When we talk about right of control, we are actually talking about the legal authority to exercise control. So meaning under the law, it gives this right to the employer to do this. So inside the statute or the agreement says the employer can transfer the employee, the employer can do this, do that, okay, the courses which this employee needs to be sent to. So meaning what is being done by the employer towards the employee, it is being stated in a set of law. Then under that situation, we say that this employee is an employee of that employer, because that employer can control it, and that employer can control this employee because there is a set of law which gives him power to do that. So okay, what about intention then? If let's say all the four tests, let's say all the three tests, we cannot use all the three tests, can we look at the intention of parties? Boleh tak kita tengok niat dia sahaja? Okay, and how are we going to determine intention? Cannot tengok niat. So when the three tests cannot be used, especially when the job is very ambiguous, then under that situation, we can use intention. And how are we going to determine intention? Not by looking at the agreement, but by looking at the fact of the case. Okay, then only we can determine whether there is an intention or for the parties to be bounded as employer and employee, whether this is a contract of service. So okay then who is an apprentice? Under the Employment Act, it says apprentice is trainee, okay? Person who is being engaged as a trainee is called an apprentice, and apprentice under the Employment Act is also considered as an employee, and because of that, an apprentice also can claim their right under the Employment Act. So now let us look at the rights of employee. These are some rights of the employee which is being given under the Employment Act, meaning this is a provision of the Employment Act. So not all the provision I'm going to discuss here. I am only going to discuss with regards those provisions which is important under your scheme of work under this Law 240. So number one, this is rights of a female employees. So meaning number one, only focus on the female employees, pekerja wanita sahaja, okay? So a female employees cannot work in any industrial or agriculture sector from 10 p.m. until 5 a.m. in the morning, so midnight, okay? Of course, it's very dangerous for a female to work at these hours. However, the Act provides that if the Director General, this is Director General of Labour, okay, gives an exemption, then the female employee can work during these hours. So that's why you see sometimes there are factories whereby they have female employees who work at night because their machines it need to keep on running, right? So why? Because they had already obtained this exemption from the Director General of Labour. Okay, and a female employee also must be given 11 consecutive hours free from work, meaning total rest, 11 hours straight. Okay, so meaning a female employee can only work plus overtime up to approximately 12 hours, because of course you say 24 minus 11 is 13. However, we must take into consideration also rest must be also given to these female employees. So approximately around 12 hours a day for a female worker. So a female worker also cannot work underground, and maternity leave should be given to a female employees for 60 days, about 2 months, up to 5 children. Sehingga 5 orang anak. Then of course you'll be asking me that why we have these female working underground on the smart tunnel in KL. Well, those female, they are not employees. Why are they not employees? Because their salary is more than 2,000 ringgit. They are professional. They are engineers. Okay, so they are not governed by this Employment Act. So okay, that is with regards to female employees. So now all these other provisions covers not only female, however it also covers male employees. So rest day. In each week, an employee is entitled for 1 whole day rest day. 1 whole day. It does not mean weekends, okay? So rest day may be on a Monday, or Friday, or maybe Wednesday. It depends on that industry. Certain kind of industry is not appropriate to give weekend as a holiday. Example like hospital, hotel. Okay, so no, it's not appropriate to give this rest day on weekend. Then under that situation, as long as there is 1 whole day rest day, then it is okay. So number 3, this is paid annual leave, cuti tahunan. So how many days of leave an employee is entitled to? This depends on how long actually the employee is already with that organization. So if the employee has been working for 12 months continuous service, however less than 2 years, so he is entitled to 8 days annual leave. Okay, if a worker is being employed more than 2 years, then 12 days. If more than 5 years, then 16 days. Can you see that? The benefit will be more if you have been with the organization for a certain period of time. This is because loyalty, okay? So can or not an employer give benefit more than what is being given by the Employment Act? Of course, more benefit is much more better for employee. Of course, can't. The employer can give more benefit but less than what is being provided by the Employment Act. That is not allowed. That is wrong under the law. That will give an entitlement to an employee to report to the Labour Office. So meaning if let's say an employee wanted to give maternity leave 4 months, can or not? Can, no problem, go on, go ahead. Okay, so if an employer wanted to give not 8 days, however 30 days, can or not? Can, no problem. Okay, so what I'm telling you is this benefit cannot be less than what is provided by the Employment Act. If it's more than what is being provided by the Employment Act, then of course it's okay. Okay, then after that, what happens if an employee does not complete the 12 months? Can the employee take this annual leave? Can. It will be calculated according to the proportion as how many months he has been in service. So let's say if the employee has been working for 6 months, then 4 days. Okay, because if 12 months, 8 days, 6 months, 4 days. So if less than half a day, that will be disregarded. So let's say, so another 1 day, then this employee will complete the 6 month. And this employee wanted to take leave, okay, 4 days because he is getting married. So half day will not be calculated as a day. So if that employee wanted to take this 4 days leave, wait until half day have over. So meaning after 2 o'clock, then he can take this leave and it will be considered as 1 day. So what happens if an employee is absent without permission? So if an employee is absent for 10% during that 12 months, then he will not be entitled to this annual leave. Tak layak dapat lah, ya. Tak ada lah cuti tahun. Sebab dah ponting kan. Okay? So what happens if during annual leave, let's say this this employee take this annual leave during Hari Raya and suddenly he falls sick and he have this MC, medical certificate. What about that annual leave he had already taken? So that annual leave will be deducted. So meaning if let's say he take 4 days annual leave, right? Then he falls sick, the MC gave him 3 days MC. So meaning these 3 days will be given back to him as if he did not take these 3 days. Meaning he actually took only 1 day annual leave. So if this leave is not taken 12 months after end of every 12 months, if this leave is not taken later than 12 months, after the end of every 12 months, then the annual leave will be forfeited. So last year, the annual leave last year is 8 days, right? So it need to be taken by this year. Okay? So meaning by this year, the employee need to finish off with all the annual leave. So let's say if the employee did not take it this year, what will happen to the annual leave? It will be forfeited, meaning the annual leave will be gone. Akan disita, hilang macam tu saja, gone. Okay? So however, if the employer and the employee agrees in lieu of that annual leave, they agrees that payment of wages will be given, okay? Then of course, it will not be forfeited and instead, a payment of wages will be given to the employee. So let's say it's not the employee who don't want to take leave, however the boss don't allow him to take employee because there's a lot of work to be done. Then in replacement of that leave, the employer can pay him wages for that day. How much? Okay? Okay, number 6. If there is termination, so let's say an employee wanted to resign, he tendered his resignation, so he can finish up his annual leave. So he wanted to resign this year on June, right? So last year the annual leave, he haven't finished it yet. Okay, finish it. And also the annual leave accrued on that year, he can take that also before he leaves the company. Okay, so if termination, that will happen. So what about unpaid leave? If an employee takes an unpaid leave for 30 days, then it will be disregarded in his computation of length of service. So meaning he will lose seniority. So let's say this lady wanted to take this 2 years unpaid leave because she wanted to follow her husband overseas. She wanted to take 2 years, right? She had been working with the company for 5 years. Whereas her friend, Rashida, is her junior. And Rashida had only been there for 2 years. Let's say. She is 5 years. So let's say she took the annual leave 2 years. When she come back, as if she only has been working for 3 years. Why? Because 2 years she is on unpaid leave. So now, her friend now, Rashida, actually have been working for 4 years. Okay, because 2 years junior plus 2 years she was on leave. Now, her junior actually overtake her. Okay, so that's why if you take this unpaid leave, you lost seniority. That's all. Okay, then what about sick leave, cuti sakit? How long actually an employee is entitled to a sick leave? So an employee cannot just simply take sick leave, simply produce a medical certificate. Cannot, because the Act provides that it also depends on how long you have been in service. If you have been working less than 2 years, that year you are entitled to fall sick for 14 days only. 14 hari dia boleh jatuh sakit. Okay? Then what happens if you need more than 14 days? Then you have to go under BB, hospitalization. You broke your arm, right? Then if you are being hospitalized, then you are entitled up to 60 days. If not, if you are not entitled to this leave, then your salary will be deducted. So if you have been working for 2 years and more, you are entitled to 18 days. If you have been working for 5 years or more, then you are entitled to 21 days. So as I told you earlier, this is because loyalty, kesetiaan kepada syarikat. Lagi lama dah bekerja, so lagi banyak benefit. The longer you have been in the company, the more benefit you will get. So to be entitled for this sick leave, of course, need to produce a medical certificate, and this medical certificate also, okay, must be from a certified medical practitioner. Okay, we are finished with these rights of employees. Now let us have a look at the duties of an employee. As an employee, what is your duties? So duties of an employee is similar to duties of an agent. I have discussed law of agency with you earlier, so I'm not going to discuss that any further. Why? Because an employee is actually an agent of the employer. The employer is the principal. So that duties will be also applicable under duties of employees. And apart from that, an employee also have duties under the Occupational Safety and Health Act under Section 24. These duties talk about as an employee, you need to take care of your safety and also the safety of your co-worker, and then you have to cooperate, okay, not only with other co-worker, with the organizations, with your employer, with regard to safety and health, okay, and if you are being provided with safety equipment, with a special equipment, I don't know what is special equipment, maybe with special shoes, with special helmet, then you have to wear this, okay. If not, if anything happened to you, you will be personally liable. And then you have to follow all instructions, all measures with regard to safety and health, which is being taken by your employer. So that are the duties under the Occupational Safety and Health Act. The 4 duties is now. So now, let us have a look at the duties of employer. As an employer, what are the duties of the employer? So the duties of the employer, actually, the duties of the principal, the 3 duties of the principal, which I have discussed with you earlier, under the law of agency, that duties also applicable plus these duties, okay? And the duties of the employer under Occupational Safety and Health Act is being listed under Section 15 and Section 16. And these are the duties under the common law, and actually these duties under the common law, these duties had already been incorporated actually inside Section 15 and 16. Okay. So let us talk about this duty of care. This is duty of the common law, duty of care. So what is the duty of care? So a duty of care is the duty of the employer to take a reasonable care to avoid exposing this employee to an unnecessary risk of injury. So meaning, if let's say an employee suffer injuries, who is liable? Then the employer will be liable. So as an employer has this vicarious liability, meaning he will be liable if the system of work is not safe enough, and because the system of work is not safe enough, the employee suffer injury. So the system of work has to be safe. So meaning, if an employee need to have safety equipment, it's the employer duties to provide the safety equipment. Okay. So if employee need to work at the place which actually is not safe, then of course it's the employer who have to take care of the situation. Meaning the system of work that need to be safe. And if an employee is being lent to other employer, so like UiTM, because we have lecturer who is an expert in many fields, and some of these lecturer is being lent to other universities overseas because of their expertise. Example is this lecturer from our FSPU, the Faculty of Architecture Surveying. They were sent to Yemen because of their expertise, and then because of riots there, we call them back. Why actually UiTM call them back? Because if actually their life is in danger, who will be liable? UiTM will be liable. So do we lend it to the universities that is not the employer that will be liable, because we are the original employer. UiTM is the original employer, then UiTM will be liable for anything that might happen to this employee. So that's why we call them back. And secondly, if employee is not insured under SOCSO, if an employee is insured under SOCSO, then it's no problem. If the employee suffer injuries, then of course SOCSO will actually cover this employee. However, don't worry, if an employee is not covered by SOCSO, employee can still claim damages under common law. And number three, this duty of care is something which is personal to the employer. The employer cannot argue that why actually this employee suffer injury is not my fault, it's the fault of the independent contractor. Okay, can the employer say that? Cannot. Okay, so because this duty of care cannot be delegated. So let's say if I fall down because the floor is slippery, because the cleaner does not clean it properly, can you attempt say, well, we have outsourced this is not our obligation. Okay, actually the independent contractor is the one who is liable. Cannot. UiTM cannot do that. Okay, the UiTM cannot shift this liability to others. Tak boleh nak alihkan tanggungjawab kepada orang lain. Okay, satu kita kata satu tanggungjawab yang peribadi. Okay, number 4, what about if actually it is the employee who is very stubborn? The employee ignore all the safety measures taken by the employer. So let's say there is a signboard saying danger and there is a red tape there, and the employee still pass through that area because there is a shortcut to the place where the employee wanted to go. Then under that situation, if this employee suffer injury, then of course the employer will not be liable. Okay, because this is the negligence of the employee. Employee is the one who we said volunteer to be injured. That last one, this duty to provide safe system of work, and last one is under the topic of duty of care. So this duty to provide safe system of work includes duty to take reasonable care. Duty to take reasonable care, tanggungjawab untuk mengambil langkah berjaga-jaga yang munasabah. Duty to take reasonable care towards that employee. If the employer fails to take this reasonable care, langkah berjaga-jaga yang munasabah, then the employer will be liable. So let us have a look at the case of Johnston versus Bloomsbury Health Authority. So what happened in this case? This Johnston, he is this junior doctor working at this health authority at this obstetric department, okay, bahagian sakit puan. So according to his contract, in a week he's supposed to work up to 40 hours. However, during call up, doctors, they are on call, right, up to 48 hours. So meaning in a week, sometime he need to work up to total 88 hours, 88 jam kan seminggu. And because of that, he suffers stress. He become depressed. Okay? And now he is suing the health authority because of this situation. And the court held actually the employers is liable. Why? Because the employer can foresee what is the injury that might actually suffered by the employee under this situation. Okay? So we go on to the next topic. This is termination, dismissal and remedies. Termination meaning the parties, either the employer or the employee, wanted to end the said employment agreement. Whereas dismissal, there is misconduct and the employee is being dismissed by the employer. So meaning dismissal is a very harsh action taken by an employer. Dismiss, buang kerja. Okay? So now let us have a look at what happens if, let's say, an employee is being terminated or an employee is being dismissed. What are the remedies which is entitled to be resorted to by an employee? So an employer can hire but cannot fire. Majikan boleh ambil orang bekerja tapi tak boleh sewenang-wenangnya memberhentikan orang. So that's why as an employer can conduct interviews and can choose who you want to become your employee. They have this right. However, once he had already hired this employee, can he just simply terminate him or fire him or dismiss him? Cannot. That is wrong under the law. And if the employer do this, of course, the employee can take this legal action against the employer. However, if it is the employee who commits breach of contract, employee yang salah laku, melanggar kontrak dia, he breach the contract, okay? The contract says you need to come to work from 8 until 5, however he come to work at 2 in the afternoon, goes back at 4, meaning he breached the contract. So under that situation, actually, he is not dismissed by the employer. He himself actually terminated his contract, and because of that, he is not entitled to the remedies which is being given by the law. Okay, so now let us have a look. If, let's say, an employee is being dismissed or is being terminated, what are the remedies which is entitled to be claimed by an employee? Kita tengoklah ni apa yang employee boleh buat. The first one, reinstatement. What is reinstatement and when can actually a reinstatement be claimed? A reinstatement is the situation whereby an employee who has been dismissed is claiming to be put back to his old post. He wanted his job back. This is known as reinstatement. If an employee can prove that he is being dismissed without just cause and excuse, meaning he is being dismissed without any reason, then under that situation, under Section 20, Subsection 1 of the Industrial Relations Act, he can actually make a representation in writing, right, to the Director General of Labour within 60 days, saying that he want to be reinstated. Tulislah surat kepada pejabat buruh, Director General yang minta untuk dikembalikan semula kepada kedudukan yang asal. Okay. So if, let's say, the employer had already given notice to him, then the 60 days, not from the day he's been dismissed, the 60 days start from the date when this notice expired. Okay? So if an employee fails to actually write within this time frame given, then the employee will lose this right. So don't wait. Straight away write to the Director General of Labour. Secondly, we are going to discuss the dismissal, once there is a dismissal, and the principle of natural justice in domestic inquiry. So once an employer wanted to dismiss, once an employer wanted to dismiss an employee, then the employer need to give natural justice to an employee, meaning an employee must be given right to be heard. So a domestic inquiry, satu siasatan dalaman need to be conducted. Okay? If an employer fails to do that, employer did not form this domestic inquiry, so meaning this employee is being denied his right to defend himself, then the employee can claim actually he is being dismissed without just cause and excuse, and he can then go under A and claim to be reinstated. So when we talk about natural justice, actually this is a rule against bias and the right to a fair hearing. And actually this principle is based on these two maxims. The ode autem patem. What is the meaning of ode autem patem? This is a right to a person who had been charged. He had been charged. You say that this employee is misconduct. Then that person must be given right to be heard before any decision is taken. So let him defend himself before you make the decision. And also, the second is said, nemo judex in causa sua, which means that no one shall be a judge if he has an interest in that particular case. Meaning, in this board of inquiry, the person sitting on the board, the person who makes the decision, must not be somebody who has an interest in that case. So meaning, if this person is the person who has charged this employee, so that person cannot become one of the board members. Okay, meaning this person who is one of the board members in the board of inquiry must be somebody who is not related to this employee. Okay, so these two maxims is the base of natural justice. So, if there is no domestic inquiry, meaning no hearing is being conducted, can an employee claim that he is being dismissed without just cause and excuse because he is not given the right to be heard? Can he claim that? So it depends. If, let's say, this case then goes up to the industrial court, then under the situation, an employee cannot claim that he is being dismissed without just cause and excuse. Why? Because during the hearing at the industrial court, he already had this right. He's been given right to defend himself. And this will actually justify what is being done by the employer. Okay, so we are going to look at these other situations whereby we say that natural justice is not being given. The first one, whether when the salary of employee is being reduced, can an employee say he is being dismissed with a just cause and excuse, he is being forced actually to leave the said job. Yes, according to the case of Amanah Basra, this is what happened. So the company involved in this business of buying and selling of currency, and the respondent in this case is actually the manager of this company, and apart from salary, this manager is also entitled to the profit of the company. So meaning he will be receiving quite a lot because apart from salary, he also received the profit of the company, of the transaction. And then suddenly, Bank Negara issued this notification saying that this company cannot share profit with their staff, with their employees. So once the employer received this notification, what happened? They gave a notice to this respondent saying that now they are not giving him this profit anymore because his performance is not as excellent as before. Okay. So meaning what is done by the company is not, they are not referring to the notification by the Bank Negara, they give another reason. They gave the reason that, well, you did not perform, so that's why we are not giving you the profit. And so now, what happened is that now the respondent, he leave the company, base, and leave the company, and now he is suing the company saying that there is constructive dismissal. What is a constructive dismissal? A constructive dismissal is a situation when an employee leaves his job, and he said he leaves his job not because he wants to leave his job, however he leaves his job because he was forced to do that. And in this case, the employee succeeded in his claim, berjaya dalam tuntutan dia. And in that case, the court did not grant him reinstatement. In fact, the court allows a compensation to be paid to him. Why? Because the court held there is mutual trust is actually lacking. Tidak ada lagi persefahaman dan kepercayaan bersama di sana. So under that situation, it is not fair to order reinstatement. And secondly, can an employee be terminated if the misconduct done by the employee has nothing to do with the business? So let's say I'm being terminated because I received this traffic summons. Can I be terminated because of that? Cannot, because it's not related to my job. Okay, this is wrong. This is against the principle of natural justice. And thirdly, if the case goes up to the industrial court level, and the industrial court held actually the dismissal actually is reasonable, meaning the dismissal is for just cause and excuse, maksudnya betul you kena dismiss sebab memang ada misconduct, you are being dismissed because there is misconduct. Cannot the industrial court then grant a reward to this employee? Cannot. Once industrial court held that a person commit misconduct, then that's it. Cannot give an extra reward there. So number 4, what about temporary employee? Can temporary employee claims that they also want reinstatement, claims that they are being dismissed without just cause and excuse because there is no domestic inquiry? Yes. In fact, a temporary employee also can claim reinstatement because if, let's say, the contract is still in existence, the contract for 6 months, now it's not even 6 months, the employee had only been working for 2 months and he's been terminated, of course he can claim for reinstatement. And number 5, what about professionals? What about doctors? What about other professionals? Are they considered as workmen under the Industrial Relations Act? You can't help. Yes, they are considered as workmen because why? Because the definition of workmen under the Industrial Relations Act is much more wider. It says that any person who has been dismissed can actually claim their rights under this act. Okay, then the final remedies. This is notice of termination. So a notice of termination is actually mandatory, not only on the part of employer, also on the part of the employee. So if the employee wanted to leave, meaning the employee wanted to resign, the employee need to give notice to the employer. If the employer is the one who wanted to terminate the employee, why terminate the employees? We are going to discuss that under section 12, section 3 later. Then the employer also need to give notice to the employee. The length of notice have to be the same inside the agreement. Okay, then when we talk about length of service, how many days actually is considered as appropriate notice? This depends on the contract of employment. However, if the contract of employment is silent because it's not stated inside the contract of employment, then we are going to refer to the Employment Act. And according to the Employment Act, if the employee has been employed for less than 2 years, then 4 weeks notice. Need to give him 4 weeks notice. He also the same. He wanted to leave, he needs to give 4 weeks notice. If he has been employed for 2 years or more, however less than 5 years, 6 weeks notice. If he has been employed for more than 5 years, 8 weeks notice. However, can or not an employee leave without giving notice? Can't, because in lieu of notice, sebagai ganti notice, as a substitute to a notice, can actually an employee pay wages. The same thing also goes to an employer. Employer fails to give notice, can actually substitute it, in lieu of notice, can substitute it with wages. So, under section 12 and section 3, this is a situation when an employee is being terminated, and if the agreement says, under these situations, the employer no need to give notice, still the Act says you have to give notice under this situation. So, what are these situations when the employee will be terminated? The first one, when the employer cease or intend to cease business for purpose employee was employed. Number 1, meaning cease business for that purpose. If an employee is being employed to sew this Barbie doll clothes in Manjung area, so now this purpose does not exist anymore. So they doesn't need an employee to sew clothes. So under that situation, this employee will be terminated. And secondly, when the employee cease or intend to cease in the place, so meaning in that place, we don't need to have this kind of employee anymore. So, and that employee is being contracted to work at that place. Then under that situation, of course, the employee can be terminated and he need to be given notice. So let's say Puringe closed down their warehouse in Ipoh. Okay, so meaning, and this employee inside their contract, and this employee is supposed to, this employee is engaged in this Ipoh branch, and now they close down their branch in Ipoh. Of course, this employee will be terminated. And number 3, requirement of that business for the employee to carry out work of a particular kind of fees. Requirement of that business, meaning that business does not require this kind of particular work anymore. So under that situation, of course, the employee will also be terminated. So example, let's say Shell, they have outsourced their driver. So meaning now, they don't employ driver to drive their tanker. So now, they outsource it, they privatize it. Okay, then under the situation, they don't need a driver anymore. Okay, so number 4, work of particular kind in the place. Number 3, of that business for them to carry out work of a particular kind, right? Whereas number 4, work of particular kind also, however, in the place at which he was contracted. Di tempat itu saja, ya, telah tiada lagi. Okay. So meaning, let's say like UiTM, so Shah Alam, we still need driver, however here in Tapah, we don't need any more driver. Okay, under that situation. So here in Tapah it have ceased. So the employee will be terminated. So number 5, if an employee refuse to transfer, okay, refuse to accept this transfer, then he will be terminated. Unless if the contract of service says it's a requirement, you need to accept transfer while you are being transferred. Because if the contract of service says if you were to be transferred, you must accept this transfer because it's the requirement of service. And if an employee refuse, this is actually misconduct. Okay. However, if it's not stated in the contract of service, however, this employee need to be transferred and he refused, then under that situation, he will be terminated. Maybe because they are closing down that branch, and because of that, they have other branch and they wanted to transfer this employee to that branch, and this employee refused to be transferred. And number 6, this is change of ownership. So we can see a lot of this situation in Malaysia. So why change of ownership? Because the company is being taken over by other companies, and under that situation, if the new companies take over this company, they will terminate the previous worker from the previous company because they have their own worker, they have their own employee. So under that situation, notice will also be given. So if an employee willfully breach the condition of his contract of service, then actually the employer can terminate him without giving notice because he is the one who is at fault. It is the employee himself who actually breached the contract of service. So if there is misconduct, so just now we have discussed about misconduct and do inquiry or domestic inquiry will be taken, and at the end of the domestic inquiry, okay, the board of inquiry can decide whether to dismiss the employee without giving him notice, dismiss him straight away, or downgraded him, okay, put the employee to a rank below than the rank now he's holding, or impose other lesser punishment, maybe a warning letter, okay. So this can be done by the board of directors, depends on the seriousness of the misconduct. During the period of inquiry, actually, the employee can be suspended for 2 weeks, and during that period of time, he will be paid half wages and not the full wages. And if at the end of the day, the board of directors decided that he is not at fault, So these, the other half wages will be refunded back to him. So can or not an employee terminate the service without giving notice? Can or not? If I wanted to leave your ATM without giving notice to your ATM, can or not? Can't. If the employee feels that his life is being threatened by danger, or maybe the life of his dependents, the life of his wife, his children is in danger. He feels there is certain kind of disease, let's say Ebola disease, so he wanted to leave the service, can't. No need to give notice. Okay? This is a notice. We're still about notice and doctrine of election. What is this? So just now I said, if let's say the employer don't give notice and in lieu of notice can pay wages. However, if the employer did not give notice and did not pay wages, however, in lieu of notice, in lieu of wages, the employer gives something else and the employee agreed to that. So let's say the employer give a car instead of giving notice, and the employer agrees to this. Then under that situation, this is okay. This is not wrong. Because why? Because the employee have agreed to that. And secondly, if an employer refuses to be transferred, you don't want to be transferred, will this actually warrant to dismissal? Meaning, can actually an employee says, well, I'm being dismissed without just cause and excuse? This depends. If the intention of the employer to transfer the employee is actually mala fide, bad intention, if the employer has bad intention, then the employee can claim actually he is being dismissed without just cause and excuse. However, if the intention of this employer is not mala fide, meaning the employer does not have bad intention, it's just that the employer need to transfer this employee, okay, then under that situation, employee cannot claim actually he's being dismissed without just cause and excuse. And number 3, if this is a summary dismissal, why is a summary dismissal? Because there is misconduct, or maybe because the employee has been charged with murder, let's say, okay. So if this is summary dismissal, of course no need to give notice, okay. And number 4, if an employee involved in misconduct, there is misconduct on the part of the employee. However, the employer had already forgiven the employees. Why we say that the employer had already forgiven the employees? Because the employer did not take any actions against the employee. 2 years had passed, and suddenly now the employer wanted to take action against the employee. Can or not? Cannot. Because it been presumed that the employer had already condoned, meaning it's been presumed that through the action of the employer, we say that the employer holds out as if they had already forgiven these employees. And under the situation, they cannot later on take action against the employees. Okay, that's all on the employment law. And if you have any questions you would like to ask me, you can always pose the questions to me. I'll be very happy to answer your question. Thank you.